Imagine waking up tomorrow and discovering you cannot move your money. Your bank accounts still exist. Your assets still exist, but you cannot spend them. You cannot transfer them, and every financial decision now sits inside a legal framework. This happens to business owners more often than people realize. And when it happens, it changes everything. Most entrepreneurs assume lawsuits are about arguments. They imagine legal debates, courtrooms, and eventually a judgment. But in many disputes, the real battle begins much earlier, before trial, before a final decision, sometimes before the case is even fully heard. That moment arrives when a court freezes assets. Today, we are going to examine what that actually means. Not just legally, but strategically, and why understanding it matters for anyone running a business. In many legal systems, courts have the power to restrict the movement of assets during a dispute. The purpose is simple. If a court believes there is a real risk that money or property might disappear before a judgment can be enforced, it can intervene. The goal is preservation, not punishment. But once assets are restricted, the environment around the dispute changes immediately. And that change is rarely just financial. It becomes structural. When an asset freeze occurs, several things happen at once. Bank accounts may be restricted. Transfers may require explanation. Spending may be limited to what the court considers ordinary expenses. In business contexts, the effects can spread further. Payments to suppliers, operational expenses, investment decisions. All of these can suddenly become more complicated. The business still exists, but financial freedom disappears. And when financial freedom disappears, behavior changes. For entrepreneurs, the psychological impact can be significant. Business owners are used to control. Control over decisions, control over time, control over money. An asset freeze removes much of that control overnight, and uncertainty grows quickly. How long will the restriction last? Will customers notice? Will investors react? Can the business continue operating normally? These questions begin to accumulate, and when uncertainty rises, pressure follows. Asset freezes do something very important inside disputes. They change leverage. One party suddenly operates with far fewer financial options. The other does not. Even if the legal arguments remain unchanged, the strategic environment shifts. Negotiations begin to feel different. Decisions begin to happen faster, and pressure can push people toward choices they would never make in calmer conditions. This is why asset freezes are often described as legal tools, but in practice they function as strategic instruments. If someone finds themselves operating under this kind of constraint, discipline becomes essential. The first instinct is usually emotion, frustration, anger, urgency, but reactive decisions rarely improve outcomes. Strategic responses require something different: stability, clarity, and patience, because while pressure can distort decision-making, it does not determine the final outcome of a dispute. What often determines outcomes is preparation and the ability to think clearly while others cannot. Asset freezes are one of the least understood mechanisms inside disputes, but they are among the most powerful. They reshape financial behavior, they introduce psychological pressure, and they alter leverage long before any judgment is delivered. Understanding how these dynamics work does not eliminate pressure, but it allows you to recognize the environment you are operating in. And recognition is the first step towards strategic clarity. If you are navigating a high-conflict legal or commercial dispute and need structured strategic perspective, including leverage mapping and risk framing, you can request a private strategic assessment through the link below. This is not legal representation. It is strategic analysis designed to help you think clearly under pressure. I review a limited number of matters each month. Most disputes are not lost in court. They are lost in preparation. This is the strategic brief.